I'm calling to order this meeting. This is a regular meeting of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Tuesday, May 7th, 2024. The time is 11:29 in the morning, and this meeting is being held in the Council Chambers, Room 500 of the John A. Wilson Building. This meeting will be followed by a regular monthly legislative meeting. I misspoke at the beginning. This is an additional meeting of the Committee of the Whole, not a regular meeting. The difference being that this is not our regular scheduled third Tuesday of the month meeting of the Committee of the Whole. But this meeting will be followed by the regular legislative meeting for the month of May. We have four items for markup in the Committee of the Whole, two measures that were reported out of the Housing Committee for consideration. And that is our business for this meeting. We begin our Committee of the Whole meetings with determining whether we have a quorum, at least 7 members present. Mr. Cash, would you call the roll?
Chairman Mendelson.
Present.
Councilmember Allen. Here. Councilmember Bonds.
Here.
Councilmember Fruman. Councilmember Fruman, Councilmember Gray. Councilmember Gray, Councilmember Henderson.
Here.
Councilmember Lewis George.
Here.
Councilmember McDuffie.
Here.
Councilmember Nadeau.
Here.
Councilmember Parker. Here. Councilmember Pinto. Councilmember Pinto, Councilmember Robert White. Councilmember Robert White, Councilmember Trayon White.
Present.
Mr. Chairman, you have a quorum.
One absent. Thank you, Mr. Cash. So we have 4 items for markup. The first is PR 25-500, which is entitled, it's got a long title, Transfer of Jurisdiction of Lots 287 and 998 in Square 5865, part of lots 981 and 982 in Square 5865, part of parcel 240/6, part of parcel 234/41, and a portion of Reservation 421. SO 14-20429, approval resolution of 2024. This resolution would approve the transfer of jurisdiction of approximately 752,831 square feet of land from the United States General Services Administration and from the United States Park Service to the District of Columbia. The transfer of jurisdiction is necessary for the completion of the substantial improvements to the I-295 Malcolm X Avenue Southeast interchange related to the relocation of the Department of Homeland Security to the St. Elizabeth's West Campus. The Department of Homeland Security headquarters consolidation at St. Elizabeth's final master plan was approved by the National Capital Planning Commission in January 2009. The plan called for a new access road and improvements to the Malcolm X Avenue interchange to accommodate increased traffic. The preliminary design for the new access road and interchange improvements was approved by NCPC in June 2015. The preferred roadway alternative put forward by the GSA included the construction of 6 new bridges, miles of retaining wall, and a shared use path along a portion of Interstate 295, as well as improvements to stormwater management systems. Construction of the interchange improvements began in the summer of 2018. Construction was completed in February 2022. This legislation would transfer the jurisdiction of 17 parcels of land from the General Services Administration and the National Park Service to the District of Columbia. 6 of the parcels are currently under the jurisdiction of the GSA, with the remainder under the jurisdiction of the National Park Service. The parcels encompass infrastructure areas that support the new mile-long access road. Ownership of the sites would remain with the federal government, but the district would maintain the stormwater management and green infrastructure areas under the transfer agreement. This legislation was introduced at the request of the mayor on October 26th, 2023. The Committee of the Whole held a public hearing on March 20th, 2024. The committee has received no testimony or comments in opposition to this legislation, nor has it received comments from any advisory neighborhood commission. I move the print with leave for staff to make technical and conforming changes. Is there discussion? The vote will be on the print with leave for staff. All those in favor say aye. Aye.
Aye.
Are there any opposed? Hearing none, the Ayes have it unanimously. I move the report with leave for staff to make technical conforming and editorial changes. Is there discussion? All those in favor of the report with leave for staff, say aye. Aye. I'll try that again. All those in favor say aye. Aye. Now, that wasn't much better. All those opposed? Hearing none, the report is approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed,
And Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Is a fiscal impact statement required on a resolution?
Yes, in this case,
And it's of no impact.
and funds are sufficient.
Thank you. Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The next measure for markup is Bill 25-568, entitled Dedication of Lot 841 in Square 5755 for alley purposes, SO 22-01599, Act of 2024. This bill would dedicate Lot 841 in Square 5755, which is in Ward 8, for public alley purposes. The dedication of Lot 841 would widen an adjacent public alley from 20 feet to 24 feet, thereby enabling the applicant for the dedication to build single-family homes on lots 839 and 840, which abut Lot 841. The existing alley must be widened before the applicant can develop lots 839 and 840 due to the zoning regulations that establish minimum alley record lot frontage requirements. And I will add, this is off of W Street Southeast. This legislation was introduced at the request of the mayor on November 7th, 2023. The Committee of the Whole held a public hearing on this measure on March 20th, 2024. The ANC 8A voted unanimously to support the dedication of Lot 841 in Square 5755. And the committee received no testimony or comments in opposition to the legislation. I move the print with leave for staff to make technical and conforming changes. Is there discussion on the print? By voice vote, all those in favor of the print with leave for staff say aye. Aye.
Aye.
Are there any opposed? Hearing none, the ayes have it unanimously. I move the report with leave for staff to make technical conforming and editorial changes. Is there discussion? All those in favor? This is the report, say aye. Aye.
Aye.
I think one person said aye twice and four didn't say anything. Yeah, are there any opposed? Hearing none, the ayes have it unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
once the report is filed,
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
And there's no fiscal impact?
Correct.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The third measure for markup is Bill 25-669, entitled Unlawful Restrictions in Land Records Act of 2024. This bill makes two changes to the law. First, it establishes, I think it actually makes more than two. It establishes a process to allow homeowners and homeowner associations to remove unlawful restrictive covenants from the land records pertaining to their real property. The bill also declares any covenant or deed restriction void and unenforceable as contrary to the public policy of the district if the restriction was put in place prior to the adoption of the zoning act, and if the restriction would otherwise be permissible under regulations adopted pursuant to the zoning act. The bill consists of primarily a uniform law recommended by the Uniform Law Commission. And then in addition, some provisions that were in a bill introduced by Councilmember Fruman. The uniform law contained in the committee print establishes a simple and uniform basis for characterizing the class of unlawful restrictions in land records to which the act applies. Restrictive covenants can offer valuable land use governance and are not necessarily unlawful. The Uniform Act focuses on covenants that are in fact invalid or unlawful and limits application to those covenants in land records that are unlawful because they purport to restrict on the basis of legally protected status or characteristics of persons, such as race or religion. The uniform law also creates a mechanism for common interest communities such as condominiums to remove unlawful restrictions not only in land records, but in governing instruments for the community. The uniform law also addresses how land records containing unlawful restrictive covenants are treated in practice. While on the surface, the aim of the law is to remove or delete the offending records, for a number of reasons, excising the covenants would be impractical or have legal ramifications. In response, uniform law, quote, unquote, removes the covenant by allowing property owners to record an amendment to a land record to clearly eliminate the purportedly continuing effect on the title. In addition to the provisions of the uniform law, the committee print adds a section that would waive any fees for releasing unlawful restriction from a deed or other governing document by an owner or common interest community. The committee print also includes a provision similar to two bills introduced in the council by Councilmember Fruman to declare a covenant restricting the building of apartments as void and contrary to the public policy of the district if the covenant predates the zoning act and where the development would otherwise be allowed under the regulations promulgated pursuant to the zoning act. This provision would apply to any property in the district that may be found to have such restrictive covenant. This legislation is taken from three bills that were introduced on September 18th, 2023 by Councilmember Fruman and co-introduced by several council members. And the committee of the whole held a hearing on those bills, Bill 25-480, 25-481, and 25-482 on December 8th, 2023. Bill 25-669 as was introduced on January 12th, 2024, and a public hearing was held on March 12th, 2024. As I said, the committee print before us, which is entitled or is designated as Bill 25-669, consists of that uniform law with some changes plus some provisions taken from one of the bills introduced by Councilmember Fruman. As I said, the committee had a hearing, two hearings, and with regard to the uniform law, there was no testimony in opposition to that legislation. I move the committee print with leave for staff to make technical and conforming changes. Is there discussion?
Mr. Chairman,
Councilmember Fruman.
thank you very much. Thank you very much, Chairman Mendelson, and to the committee of the whole staff for all of the work that you've done on this issue, especially Evan Cash. Thank you, Mr. Cash. I found out that there was a covenant on the house that I live in and that we raised our children in a number of years back and did a column in the Washington Post about it. It was a shocking revelation to me that we had such a covenant on our house. And I think addressing those historic covenants and becoming aware of them and then addressing them is a key part of building a better world. And so I came forward with draft legislation on how to lift such covenants. It turned out that the Uniform Law Commission was already working on something similar, and it achieves the same goals. I do think one of the innovations we had was the waiver of costs, and the Uniform Law Commission, I think, is going to take that on in the work that they're doing. So I think this is an example of everybody working together to get to a shared goal. The second piece is also critically important, and I really want to thank you, Chairman Mendelson, for your work on this. There are covenants on certain properties that prohibit multifamily housing in places where multifamily housing is a high priority, and that the city, through its policy in the zoning code and the comprehensive plan, has determined that multifamily housing makes sense in those settings. What's done here is both limited and broad. It's limited in the sense that The only covenants affected are those that predate the zoning code. That is covenants that are close on 90 years old. And so we've done a lot of thinking about what should go where since then. And I don't think we should be bound by decisions made at least 90 years ago, in some cases 100 years ago, and often driven by a desire for exclusion. What's done is even-handed. It says that such covenants against multifamily housing in a place where the zoning code now, such very old covenants against multifamily housing in a setting in which multifamily housing is allowed now are null. And it applies that the impetus for this started in Rock Creek West and partly in Chevy Chase, DC, but what the legislation does is citywide in effect, which I think is wise and helps us to achieve our goals, not just in Rock Creek West, but throughout the city. So I'm very grateful to you, Chairman Mendelson, for your work on this bill, and look forward to supporting it and hope my colleagues will as well.
Thank you, Councilmember Fruman. Is there any further discussion? Hearing none, the vote will be on the print with leave for staff. All those in favor say aye. Aye.
Aye. Aye.
Are there any opposed? Hearing none, the print is approved unanimously. I'll move the report with leave for staff to make technical, conforming, and editorial changes. Is there discussion on the report? By voice vote, all those in favor say aye. Aye. Opposed? Hearing none, the report is approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed?
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The fourth and final measure for markup in the committee of the whole today is Bill 25-786, fiscal year 2025 Federal Portion Budget Request Act of 2024. This legislation was introduced at the request of the mayor, along with a number of other measures, all related to the fiscal year 2025 budget. The fiscal year 2025 Federal Portion Budget Request Act reflects the portion of the budget for fiscal year 2025 that is made up of federal payments. This legislation is treated the same way we used to treat all of our budget legislation. That is, comes before the council for a single reading, is then given to the mayor, then submitted to Congress, but Congress ultimately decides the appropriations for the federal portion of the fiscal year 2025 budget. Of the district's fiscal year 2025 operating budget, as proposed by the mayor, which she proposes to be $21.1 billion, the vast majority, $15.7 billion, is raised locally through district taxes and fees or derived from other local sources. This means local dollars account for 74.2% of the district's total budget. I'll repeat, 74.2% is local funds, local dollars. Most of the rest, $5.2 billion, is federal formula spending that includes Medicaid and federal grants available to all jurisdictions and for which the federal government has no oversight responsibility unique to the district. Federal formula spending accounts for 24.5% of the district's total budget. Overall, approximately 99.2% of the district's budget is derived from local revenue and federal formula grants that are not unique to the district. Less than 1% comes from federal payments specifically requested for local programs or projects. This is quite different than in the 1990s before the Revitalization Act, when the district received, I think it was close to 20% of its budget as a federal payment. Let me see. I'm reading excerpts from the report. In addition to the bill's request for federal payments to the district, this Budget Request Act sets forth desired federal funding to support, in whole or in part, other entities that serve district residents: the courts, the Public Defender Service, the Criminal Justice Coordinating Council, the National Guard, 2 judicial commissions, University of the District of Columbia, DC Water, and the Washington Metropolitan Area Transit Authority. The bill also seeks to strengthen local government and the district's economy through the provisions in sections 3, 4, 5. Section 3 allows the mayor and the council to determine the chief financial officer's salary, which Congress has failed to keep competitive. Section 4 strengthens the council's role in containing spending by ending the mayor's unilateral ability to spend contingency reserves. Section 5 enables the district to expand its sales tax base to include non-governmental retail sales on federal property, such as tourist-oriented gift shops. Section 6 and 7 also make needed changes to federal law. Section 7 improves the DC Tuition Assistance Grant Program by increasing maximum grant amounts in response to the rising cost of college. Section 7 facilitates continued operation of the National Children's Museum in downtown DC. The federal payment under this, the committee print, the federal payment for the District of Columbia courts would be just under $360 million. The federal payment for court services would be $310 million. Federal payment for public defender services, $105 million. And I believe the bill also addresses an issue with regard to, that was recently in the news with regard to an appropriation this year. The federal payment for resident tuition support would be $40 million. That's DC TAG. For school improvement, that's the 3-sector funding from Congress is $52.5 million. Federal payment to the University of the District of Columbia would be $10 million for laboratory improvements at the UDC. For the Criminal Justice Coordinating Council, which would be a portion of their budget, $2.5 million. The judicial commissions would be $1,056,000. To the National Guard, this would be a portion of their budget, $600,000. To support the Major General David Worley District of Columbia National Guard Retention and College Access Program. For the federal payment for testing and treatment of HIV/AIDS, $5 million. Emergency planning and security costs, which is a reimbursement to the Metropolitan Police Department for expenses incurred in providing public safety at events related to the status of the district as the nation's capital, including support requested by the Secret Service in carrying out protective duties and support to respond to terrorist threats or attacks in the region, as well as for the presidential inauguration, that's $97 million. To DC Water, $22.4 million, which includes in part the combined sewer overflow long-term control plan. I think they call that Clean Rivers. Federal payment to WMATA, $200 million. This legislation was introduced at the request of the mayor on April 2nd. That's not what this says. It says on April 3rd. And the committee of the whole held a public hearing on May 3rd with 172 witnesses. I move the, if there's no objection, I'll move both the print and the report together with leave for staff to make technical conforming and editorial changes. Is there discussion?
Mr. Chairman.
Councilmember Henderson.
Thank you, Mr. Chairman. I have an amendment to this bill that was circulated by my staff at 10:57 this morning. I'm introducing this amendment to include additional requests that Congress provide an additional federal payment of $5 million to the district for the Early Childhood Educator Pay Equity Fund. Not a lot of people realize that there are several child development centers that are located in federal agency buildings in partnership with the General Services Administration. These centers are licensed by the Office of the State Superintendent of Education, and as such, those employees qualify for participation in the district's Pay Equity Fund. The federal government benefits from the Pay Equity Fund in the way of higher educator salaries and lower childcare costs for parents who are congressional employees, members of Congress, and federal agency employees. As we look to restore cuts that are being proposed to the Early Childhood Educator Pay Equity Fund, I believe it's only fair to ask that the federal government contribute in recognition of these benefits that district taxpayers have been making possible thus far. I hope that you'll accept this amendment as friendly.
If there's no objection, the amendment will be accepted. Hearing no objection, it is accepted.
Thank you.
Is there anything further with regard to the bill?
Chairman, I just wanted to-
Yes, Councilmember Lewis George.
yes, because I'm, this is gonna be on the consent agenda. Chairman, I just wanted to note the DC tag portion of this and how important it is. And actually, Chairman, isn't it true that the last time DC tag, got a raise was in 1999? And so students in the district have not seen an increase of this nature since 1999, when college and university costs have gone up, and having this change go from 10,000 to 15,000, with the lifetime cap raising from 50 to 75,000, would go to really supporting our young people and their ability to be able to go to college and afford college. And so would make, this is something that many families have been asking for a number of years here in the district, and rightfully so. And so I think this is really important and something that we should highlight, and wanted to make sure you agree with that as well.
Of course, I agree with it. This is a markup, so it's not limited to questions, but I believe you're correct that it's been 2 decades since there were adjustments to the what TAG provides.
Absolutely. Thank you.
Thank you. Anything further on this bill? Hearing none, the vote will be on both the print and report with leave for staff. All those in favor say aye. Aye.
Aye.
Aye.
Opposed? I hear no votes. The print and report are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is. I'm sorry. No, it isn't. Once the report is filed.
Well, also, we have to file the hearing record from last week's hearing, and the record is open except for this bill for 2 weeks. Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Is there a fiscal impact on this?
There is
statement?
not, because it's just a request.
Thank you. Without objection, this measure will be placed on the consent agenda for today's legislative meeting. That concludes items for markup in the committee of the whole. We have 2 measures that were reported out of the Committee on Housing chaired by Councilmember Robert White. They are both confirmations of nominations by the mayor to the Rental Housing Commission. PR 25-639, Rental Housing Commission, Adam R. Hunter, confirmation resolution of 2024. And PR 25-663, Rental Housing Commission, Lisa M. Gregory, confirmation resolution of 2024. Councilmember White.
Thank you, Mr. Chairman. I want to make sure I'm doing these in the right order. I think we're starting with Adam Hunter, is that right?
Yes.
Okay. When landlords and tenants have disputes over issues like rent increases and rent-controlled buildings, parties can take their claims to the rent administrator or the Department of Housing and Community Development, or to the Office of Administrative Hearings. The losing party can then appeal the decision to the Rental Housing Commission. The commission serves as an independent appellate body for those cases and is comprised of 2 administrative judges and 1 chairperson. Judge Adam Hunter currently serves as the acting chairperson of the commission. PR 25-639 would officially appoint Judge Hunter as chairperson for a term to end July 18th, 2025. At the hearing on his appointment, Judge Hunter testified to the Committee on Housing about his experience leading his own law firm for 11 years prior to joining the commission. He described his firm work as similar to the daily tasks of leading the commission, and shared that he has represented both landlords and tenants in OAH cases, which provided him with a working knowledge of the cases over which he now presides. Judge Hunter's former business partner testified that Judge Hunter's working knowledge from those cases, as well as his fiscal responsibility and organizational skills, make him best suited to lead the commission. I appreciated these testimonies about Judge Hunter's skill sets, as well as his goal to make the commission more user-friendly. Many parties represent themselves pro se in commission cases, and Judge Hunter shared that he intends to lead the commission in creating resources understandable to the average reader, including drafting clear opinions and making sure the commission's role makes sense to people. I agree with this vision and believe Judge Hunter will be an effective leader. I encourage the council to approve proposed resolution 25-639, the Rental Housing Commission Adam R. Hunter confirmation resolution of 2024. Without council action, this measure would be deemed disapproved on May 29th, With that, I move PR 25-639 and request that it be placed on the consent agenda of the legislative meeting later today.
Thank you, Councilmember White. Are there questions from members? And this is limited to questions. I have three. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
And there's no fiscal impact statement required for nominations,
Correct.
but I'm required to ask the question. Thank you. Without objection, these two measures will be placed on the consent agenda for today's legislative meeting. That concludes,
Chairman.
what I forget.
Lisa Gregory.
Oh, I moved them in, I present,
Oh, I heard Lisa Gregory. I thought you got him out of order. So my apologies.
go
But
for
good
it.
thing you were listening to my statement closely.
It was.
Next measure,
You said you had a hearing on it.
we,
You
we,
said you had a hearing on
we
it.
did.
Yeah.
PR 25-663 would confirm the reappointment of Judge Lisa Gregory as a member of the commission for a term to end July 18th, 2026. Judge Lisa Gregory currently serves as an inactive commission member because her tenure and holdover period have expired. Judge Gregory, however, remains employed at the commission pending appointment and confirmation. At the hearing for her reappointment, Judge Gregory testified about the commission's accomplishments during her 6-year tenure. This included publishing a large revision of the district's municipal regulations to implement the Rental Housing Act, which is one of the pillars of the commission's work. In her written materials, Judge Gregory described her 22-year legal background, which has included work in the constitutional law, employment law, civil rights, contract compliance, mediations, and negotiations. If reappointed, Judge Gregory said she would like to continue efficiently and fairly deciding cases and to increase training opportunities for commission members. I appreciated Judge Gregory's emphasis on trainings, particularly for judicial bodies responsible for decisions that directly impact the lives of district residents. Adjudication must be unbiased and fair, and trainings can support objective decision-making. I also found it helpful to hear more about her experience on the commission as it transitioned to an independent body. For those reasons, and because she meets all of the statutory requirements to serve on the commission, I recommend that the council approve PR 25-663, the Rental Housing Commission Lisa M. Gregory Confirmation Resolution of 2024. Without council action, this measure would be deemed disapproved on June 12th, 2024. With that, Chairman, I move PR 25-663 and request that it be placed on the consent agenda of the legislative meeting later today.
Thank you, Councilmember White. I'm assuming there's no questions from members. I don't know if the clearances were done for both, so I'll ask General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes.
Madam Budget Director?
Yes.
Thank you. But it's not required. Without objection, this measure will be placed on the consent agenda for today's legislative meeting. Councilmember, may I conclude the meeting now?
You may, Chairman.
Thank you. If there's no other business, not that I'm actually asking, the time is 12:02 PM and this meeting is adjourned. I'm calling to order this meeting. This is a regular meeting of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council. This is our 23rd legislative meeting of Council Period 25. Today is Tuesday, May 7th, 2024. The time is 12:42 in the afternoon. This meeting is being held in room 500 at the council chambers of the John A. Wilson Building. I don't believe there are any members who are participating virtually today. We always begin our legislative meetings with a moment of silence. Before we do that, I want to recognize Councilmember Charles Allen.
Thank you, Mr. Chairman. I appreciate that, and I did want to just note unfortunate news, but also appreciation to my colleagues and the council. Lost a longtime member of the council, Nate Bell, who passed away last week. I want to thank my colleagues and as well as all of our council staff that reached out to myself and our staff. And we are still mourning, obviously, the passing of Mr. Bell. Nate was born in DC. He was called to public service. He worked here at the council, not just for myself, but for Councilor Anita Bonds, who I'm going to turn to in just a second. But he also worked for Mayor Bowser and is just was a remarkable person, somebody that we absolutely loved working with, who cared and loved deeply for his city and worked very hard to make a difference in our city every single day. And so his passing is tragic and we're grieving that, but I just wanted to appreciate my colleagues and all our community members who've reached out. And I wanted to see, because he worked for Councilor Bonds for a very long time as well, if Councilor Bonds wanted to add anything.
Councilmember Bonds.
Thank you very much, Chairman, and thank you, colleague, Alan. You know, Nate Bell was a warm and fuzzy kind of personality, someone who assured you that the work would get done. And that's what we all desire in this world, in fact. And his passing was too soon. I think of him as a young man in the prime of his life. In fact, we were saying to him, you got to get those babies going. You know what I mean? Having some lineage there. He worked for me a few years ago and left the council with the intention of going to the operating side of government. And that he would get on with raising this family. And then he came back. He came back because he had this exciting opportunity to serve again in this arena. He knew this arena very well, coming from Bloomberg as a writer. And so I'm sure as I embraced him, that he was well embraced by Councilmember Allen. Yes, he will be missed. And I must say, when all is understood about his early passing, we have to remember that the mental health, the health in general of our workers are just tantamount to moving forward in this world. We are not just islands into ourselves. We become family as we work together, and we want to look out for each other to the best of our ability. So we just have to be conscious of that. And as within my committee, I have the Department of Human Resources. And one of the things we want to do is to make sure that well living for the employees of the District of Columbia is I'll say expounded throughout so that we all can have a good and robust life within our offices and what we do. So I went on a little bit longer, went into too much detail perhaps, but I think it's important that if we're going to talk about it, let's talk about it and let's put it on the table because it affects each and every one of us. So thank you very much, Chairman, and thank you also, colleague.
Thank you, Councilmember Bonds. Thank you, Councilmember Allen. If we could have a moment of silence in the chamber, please. Madam Secretary, would you please call the roll?
Councilmember Allen,
Here.
Councilmember Bonds,
Here.
Councilmember Freeman,
Here.
Councilmember Gray. Councilmember Gray, Councilmember Henderson,
Here.
Councilmember Lewis George. Here, Councilmember McDuffie,
Here.
Chairman Mendelson,
Present.
Councilmember Nadeau. Here. Councilmember Parker,
Here.
Councilmember Pinto,
Present.
Councilmember Robert White,
Present.
Councilmember Trahan White.
Present.
Mr. Chairman, you have a quorum.
Thank you, Madam Secretary. We have the Secretary's report of committee filings. I'm going to recognize the Chair Pro Tem, Councilmember McDuffie.
Thank you, Chairman. I'll move to waive the reading of the Secretary's report.
To the motion to waive the reading of the report, is there discussion? On the motion to waive the reading, all those in favor say aye.
Aye.
Opposed? The ayes have it unanimously. We have the Secretary's report of introductions and referrals. Again, I'll recognize the Chair Pro Tem, Councilmember McDuffie.
And I will move to waive the reading of the Secretary's report of introductions.
A motion to waive the reading, is there discussion? On the motion to waive the reading, all those in favor say aye.
Aye.
Opposed? The ayes have it unanimously. We have the consent agenda before us. Councilmember Freeman, you wanted to remove item F1 on page 5.
That's right, Mr.
Correct.
Chairman. Thank you very much.
Are there any other changes to the consent agenda? We have the consent agenda before us. We'll do a roll call on this, Madam Secretary.
Councilmember Pinto,
Yes.
Councilmember Pinto votes yes. Councilmember Robert White,
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White,
Yes.
Councilmember Trahan White votes yes. Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Councilmember Bonds votes yes. Councilmember Freeman,
Yes.
Councilmember Freeman votes yes. Councilmember Gray is absent. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George,
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie,
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson, Councilmember Nadeau,
Yes.
Councilmember Nadeau votes yes. Councilmember Parker,
Yes.
Councilmember Parker votes yes. Chairman Mendelson,
Yes,
Chairman Mendelson votes yes. Mr. Chairman, there are 12 yeses.
and 0 no's. The consent agenda is approved unanimously. We have before us Bill 25-781, Local Rent Supplement Program Eligibility Temporary Amendment Act of 2024. I moved this as an emergency at the last legislative meeting, and it was approved. I thought unanimously, maybe there was 1 no vote. And this is the temporary for second reading. I was prepared to talk about this later in the agenda, but this is somewhat related. This bill maintains the status quo that has been the law since July of 2022, when the council passed an emergency, which the mayor signed. I have to emphasize the mayor signed, to make it easier for those who are homeless or those who are undocumented to get vouchers that then they can use to apply for rental housing. I don't think this was clear at the breakfast, but this is about getting vouchers. This is not about actually getting into the units. That's a separate application process. And this legislation simply removes barriers so that it will be easier for those who are homeless, who do not have readily available identification documents like a birth certificate, and those who are undocumented to be able to apply for a voucher. So I move the temporary. Is there discussion?
Thank you, Mr. Chairman. I voted against this bill in the first reading and will be again. I hear you that this is an extension of the way in which we've operated for a while, coming out of COVID, and a real strong desire to lower barriers. And I understand the impetus to lower barriers. There is, however, a lot of issues around this program. And one of the things this does is eliminate any control going in. We talked at the breakfast about the challenges of providing services to folks once they're in the program, and the reality that services are voluntary. And so we have lots of issues around that. And then we also talked about challenges when a a resident may be causing very serious problems for other residents and the employees of the housing provider. We need to take a hard look at this program and figure out how we can make it work for everyone, including the other tenants who are in a building. And so I'm reluctant to just keep the status quo in the way that you're talking about the status quo. And that's why that's why I voted against it last time. And that's why I'll be voting against it this time. I do hope there's been talk about permanent legislation to address these issues. That should be a very high priority of this council because we all want this program to work. It's not working in the way, in many, many cases, it is working in a way that is terrific, but there are cases where it's not working in a way that's terrific. And if we want to maintain support for it, we need to fix those issues. And this is a part of that.
Thank you, Councilmember. I don't want to belabor this, but this again, and I didn't make this clear at the breakfast, this is about applying for a local rent supplement voucher. It is not about applying for an apartment. People who get a voucher then apply for an apartment. So when there's concern, rightfully, with regard to challenges when residents are causing problems, that's not this. That's the subsequent step. That is the rental apartment application. This is about getting a voucher and reducing or eliminating barriers to those who are homeless or who are undocumented to get a voucher. I will add that there was a hearing on the permanent version of this law at the Housing Committee hearing last summer, and the Housing Authority, who's responsible for issuing these vouchers, the Housing Authority did not raise the concerns that my colleague is raising. So I ask that members support this. If there's no further discussion, Councilmember Robert White.
Thank you, Chairman. I just want to clarify, again, this is temporary in nature. The Housing Committee, which I chair, has a permanent bill introduced by the chairman that we will mark up. No one in the council, and I think anywhere else in the government, wants to see dangerous issues or people take advantage of a program. We got objection from the mayor on this bill without any specificity, any specific information about people or types of people they believe to be fraudulently engaging the program, or any connection between people who are self testing and people who are causing issues in vouchers. So when we fix an issue, let's make sure we're fixing a real issue. I worry that we do things that play on people's fears. And when we have real underlying problems, the administration is not providing wraparound services for people who have been chronically homeless. That is causing resentment and pushback unnecessarily. Real problem, we're clearing homeless encampments without a real place for people to go. And the administration will say, well, they can just go in a shelter. We'll talk to people choosing to live outside instead of in a shelter. Choosing. It's not that they don't know their beds at the shelter. They are choosing that. So we have to fix the shelters. We have to provide the wraparound service. And we will pass permanent legislation that closes any real gaps. As we do that in the coming weeks, I want to make sure that we continue what we have been doing as we move the permanent legislation, which again, we'll do it in the coming weeks. So I look forward to supporting this and appreciate your leadership on this, Mr. Chairman.
Thank you. If there's no further discussion on the bill, the vote is on the temporary bill 25-781. All those in favor say aye. Aye.
Aye.
Opposed?
No.
Madam Secretary, please record Councilmember Fruman as voting no. And the bill is approved. That takes us to the non-consent agenda. Give me a moment to find the non-consent agenda. On page 6, the first measure is Bill 25-469, Revised Project Labor Agreement Cost Threshold Amendment Act of 2024. This is for final reading. It was reported out of the Committee on Public Works and Operations. Councilmember Nadeau.
So moved, Mr. Chairman.
The bill's before us. Councilmember Nadeau, you have an amendment?
Yes. Did you want to do mine first?
Yes.
Okay, then. The intent of this amendment is to mitigate the fiscal impact of Bill 25-469 by excluding existing projects that are already in the CIP that cost between $50 and $75 million. It's estimated there are 5 such projects. With this amendment, the new PLA threshold will now only apply to any new projects that are not currently in the CIP. It would also apply to any existing projects that are now projected to cost under 50 million that are subsequently modified to cost more than 50 million. Essentially, it lowers the VIS by pushing out the applicability date. It was circulated at 10:13 this morning. So moved.
Thank you, Councilmember Nadeau. Madam Budget Director, you and I were discussing fiscal impact on this amendment. If this amendment is amended by deleting paragraph 2 and keeping paragraph 1, but removing the word first, so that the amendment simply says, this act shall apply to projects included in the capital improvement plan proposed for fiscal year 26 through 2031, or for any period thereafter, that has a clean fiscal impact.
Yes.
If there's no objection from members, then and Councilmember Nadeau is okay, I orally am modifying this to strike the word first
No objection.
and to
over here.
strike the paragraph number 2, which means, of course, that the number 1 is struck as well. So that the amendment reads in its entirety, this act shall apply to projects included in the capital improvement plan proposed for fiscal year 2026, 2020, 2031, or for any period thereafter. I'd say fiscal years, but you can fix that. And perhaps it should say and for any period thereafter.
I will gladly accept those changes as
No
friendly.
objection, that oral amendment is accepted.
No, Mr. Chairman,
And-
could you open up?
We still have the amendment.
Oh, okay.
On the amendment, is there any further discussion?
What was just, I heard you say something was accepted.
The whole bill was, Councilman. No,
Okay.
just joking.
I'm just trying to.
No, what we have before us is an amendment. So Bill 25-469 is before us.
Okay.
Councilmember Nadeau moved an amendment. My name is on it. It revises the applicability section. The applicability section shall read in its entirety, this act shall apply to projects included in the capital improvement plan for proposed fiscal years 2026 to 2031 and for any period thereafter. Period. And the budget director has indicated that that would have a clean fiscal impact.
Do we have that?
It was circulated at
Yes, from the
10:13
budget
AM and
director.
amended orally.
No. I understand. I'm looking at the amendment, but I'm talking about the FIS.
Yes, the budget director has indicated that it has a clean fist.
Do we have that? In my-
Orally, we have it.
Well, what does it cost? How does it affect the cost?
The reason why it has a clean fiscal impact is because it does not apply to any current projects what the bill does is it changes the threshold from 75 to 50 million. That change would not affect any of the projects, which I estimate is about 5 that are in the current the current CIP. If those projects are subsequently changed, then it would apply, but that would be in a budget that comes to us next year.
But how many projects are we talking about?
We think it's about, well, how many are affected by this?
5.
We think 5.
And if those projects were to change in terms of the cost going up, would they be affected by this?
Only if we vote on it next year.
So I know that I think there was a letter by the mayor she sent that talked about the costs associated with this. I haven't seen any costs. And obviously, I don't know if there's anybody better than Jim Budoff and the folks in her office. But I guess I'm just
I can
curious
speak
as to
to
what the
that.
analysis would look like.
I can speak to that, Chairman.
Yes. Councilmember Nadeau.
I saw the mayor's concerns as well, and I do want to respond to that, so thank you for raising it, Councilmember McDuffie. The mayor asserts that we are voting on this bill without knowing the full cost. And she said that because we're voting on it after she sent her budget down, which we do pretty regularly on bill. However, we have been working diligently with ORA to update the FIS, and they maintained the same cost for current projects. And with this update amendment, we will ensure the FIS is accurate and achievable.
I guess my thing is, did ORA provide us with a FIS for us to see, evaluate, and use to inform our vote?
On this amendment,
Yeah. So we know what the costs are.
Well, this amendment removes the cost.
Allegedly.
Okay,
Mr. Chairman,
Let's-
can I ask a question?
maybe we can call the question after Christina asks her question. I
yeah,
was going to accept it. I mean, okay.
who asked to be recognized?
Well, I raised my hand, but I think you heard her voice.
There's a mic down there. Somebody down there want to be
Yeah, it was
recognized?
me.
Councilmember Henderson?
Thank you. So I was at our last legislative meeting, I raised questions about the cost. And I just want to clarify that the amendment that you all, because I think in the breakfast you mentioned this would not include the 5 projects that are currently in the CIP, but then, Mr. Chairman, you just said, but then if those projects are included in the CIP next year, then they would need to be funded.
No, that's
Right.
not the.
So I
intent.
guess my question is, why are you amending it to say for the CIP for fiscal year 2026 to fiscal year 2031, as opposed to starting it with the CIP year that is currently outside the financial plan? Does that make sense?
I understand the question. All right, so let me back up here. Unless Councilmember Nadeau, you want to speak to this. The chief financial officer has issued a fiscal impact statement on the bill as came out of committee. It says there's a fiscal impact of about 10% increase to the cost of each project. Personally, I think he's wrong. This is like an urban myth that a PLA, because it requires, among other things, Davis-Bacon wages, is therefore more expensive. However, a non-union job in this area requires Davis-Bacon wages, so there really isn't a difference. But there is this myth that it drives up the cost because unions are horrible and they cost more money. Nonetheless, we live by fiscal impact statements. So until the CFO changes his fiscal impact statement, that is the cost. That is that this bill is subject to appropriation. The bill is reported out of committee is subject to appropriation until we add 10% to every project over between $50 and $75 million. Why do I say it that way? Because right now the law says that a PLA is required on any project over 75 million. I can't say definitively, but I believe there are about 5 projects in the current CIP that are between 50 and $75 million, and therefore affected by the bill as it came out of the committee. What this amendment is intended to do is to exempt those 5 projects, to exempt those 5. So next year, when a new project comes along, the mayor will have to fund this imaginary 10% cost. I mean, that's just bogus because they'll just estimate what the cost is, which they would do anyway, and it's not going to be 10% more, but in any event, she will, for the new projects, fund them. What we've been struggling with is what if there is, let's say, a school modernization that is in the CIP for surprise, $20 million. I say surprise because we see this all the time. And next year they come back and say, oh, it's going to cost $60 million. We want this law to apply then. Now, if there's a change order, so a project comes in at $45 million and the change order takes it to 55, we don't want it to apply, but I don't think it could anyway because a PLA can't be applied retroactively. A PLA is a project labor agreement that for this project, when it starts, there will be union contracts, which, by the way, could be a non-union company that agrees that for the purposes of the project, they will have a union. Their existing members could be a member of a union, or they could bring in union members, but either way, non-union companies can participate. So let me be clear, what we're doing is we're exempting the existing CIP projects that would be affected by the committee print so that we don't have a fiscal impact. But we're saying that new projects next year and thereafter would be covered, and a substantial modification such as I described next year, not now, would be covered.
Okay. Very crafty, because I think we both know we have yet to ever see a modernization project that didn't have additional costs added in a future CIP.
Not so sure about that. I think the convention center came in under budget and on time, and I think the South Capitol Street came in under budget and on time. National Stadium was very controversial, but I think it might have come in under budget and on time. Those were all PLAs. Usually the city does a pretty good job when it negotiates a PLA for a project. Also note, just because you're looking at me, that the President of the United States has said that for federal projects, PLA threshold is 35 million, not 50. Councilmember Nadeau, anything I left out?
No, I see there's a number of questions. I want to make sure they're all about this amendment, because if not, we can dispense with it and move to the underlying measures and the other amendments before us.
Good point. So this amendment simply deals with the applicability section to eliminate the fiscal impact. If there's no further on this amendment.
Mr. Chairman, I had one quick question. And it may be, I mean, I'd like this to apply. So if there's a project that is in the current CIP for FY28, for example, so it's off into the future. Right now, this isn't applying to that, but next year when there's a new CIP for FY26 through 32, what will that new entry in the CIP, in a new CIP, will it govern there?
As this is written, if the project in next year is the same as this year, then no. As this is written, if the project next year is changed, increased, then yes. Because if the mayor is going to increase the cost of a project, then she can factor in this purported cost from the PLA.
I mean, I guess I support the underlying initiative. I worry about a merry-go-round because we're going to do this, then the mayor next year is going to repeal it in the BSA, not fund it in the CIP, and then are we going to be in the same place? So it's a challenge when hopefully the kind of mechanism I'm getting in front of myself.
Well,
but
my guess is that the CFO will not certify the 10% savings from projects because they're like, it's just a made up thing. Yes, Council, on the amendment, Councilmember Vaughn.
Yes, on the amendment, I just want to thank you for trying to explain this change order in modernization projects. I think it makes a difference to understand that concept. I would be interested in seeing in black and white what constitutes a change order and what is this other thing that you mentioned, which could be could increase the cost. So
I'm pretty clear that this doesn't, change orders are outside the scope of this.
that's what I'm hoping. Thank you very
Yes.
much.
There's nothing further on the amendment.
I wanted to ask a question about the actual FIST that, there is a FIST that the CFO provided, correct?
Correct.
What does that attribute the increased cost to? Because I understand that there's Davis-Bacon, and you made the point that Davis-Bacon applies to non-union jobs as well. But I understand that there are costs that the CFO laid out that are not related to the Davis-Bacon.
Well, there's this belief that a PLA costs more because union contracts cost more and because requiring union work therefore limits the pool of applicants. This is an issue that I've gone around and around with the CFO for a number of years, because remember, we did this legislation a few years ago at 75 million and had the same disagreement with the CFO then. I believe in this market, it isn't restricting. We didn't see that with the South Capitol Street Bridge that I'm aware of, or with the Washington Convention Center, or the Nationals, or any of the other PLAs that the cost, oh my God, they came back to us, the costs went up because we had a PLA. I've never heard a complaint about a PLA other than when we deal with this legislation. And then it is non-union shops who don't want to participate in a PLA who object. So that was a long answer. The CFO contends that union work costs more and that requiring a PLA limits the pool of applicants. Councilmember?
Okay.
So if there's no objection, the amendment will be accepted?
Yes.
I
Is it a yes like an objection, or
I
is
think
yes
we
like
should
that
vote
it's
on it.
accepted? All right, on the amendment, all those in favor of the amendment say aye.
Aye.
Opposed?
No.
The ayes have it. We have the bill as amended before us. The agenda, which I've misplaced.
Chairman, there's an amendment from Councilmember Parker that should be considered next.
Thank you. Councilmember Parker.
Thank you, Mr. Chairman. I circulated an amendment last week. It's pretty straightforward. It seeks to address concerns raised at our last legislative meeting about the potential for negatively impacting the district's CBEs, which none of us want to do. Specifically, this requires PLAs and those who contract under the PLA to outline how the project will benefit CBEs and to create a plan and thereafter specific outreach for certain groups in disadvantaged communities, including women. And I'm gonna skip the technical language, but happy to talk more about it if there are any questions.
I do want a clarification. You circulated the amendments linked to the agenda, but then you recirculated today. I think it was just to fix a typo.
Yes, it was a technical adjustment to address a typo.
A typo. Okay, so substantively, it's the same.
That's right.
Councilman Nadell?
Mr. Chairman, I'd like to accept the amendment as friendly.
If there's no objection, the amendment is accepted. I did not say that with the correct tone. Being no objection, the amendment is accepted. Councilmember Tran White, you circulated an amendment?
Yes, a circulated amendment, created some changes to my amendment, which I circulated in writing and email at 12:06. This amendment, is amendment to D 25-0469 to revise the project labor agreement cost threshold amendment act of 2023. The new amendment only includes an exemption from CBEs, from PLAs. The DC Council, Office of General Counsel supports our amendment as legal. And to Councilmember Parker's point, we do not want our local businesses to be adversely affected. I support and believe in unions. I think unions have a crucial role in training, also employing residents. I think historically in the district, we have to do more to bring on DC residents. When I ask union representatives about DC residents, it's a lot of barriers, meaning you can't find workers, can't keep workers. And I've been on a interviewing tour, interviewing people from unions that work on the unions in DC, and some of the same themes occur. Meaning they say, Mr. White, I'm in a union, but the reality is I think because a job is coming up in our ward, I think I'm supposed to be on the job. I get on the back seat because people from out of town who have preference in the union come from out of town and take my job. And it's happening over and over again. Oh, I have an issue with my employer. I call my union, but I'm not getting the adequate representation. And there are good and bad stories, but I'm hearing this type of story far too often in the district. And so I support our PLAs, but I don't want to create a issue where our CBEs are left out of the equation. So this amendment attempts to exempt CBEs from the PLA bill that's been presented, the PLA amendment that's been presented today with lowering the threshold to $50 million.
Thank you, Councilmember White. Councilmember Nadeau?
Thank you, Chairman. I cannot accept this amendment as friendly and I do not support it. And while I appreciate Councilmember White's instinct to strengthen project labor agreements and its support for residents, unfortunately, this amendment to exempt CBEs from the PLA law defeats the purpose of the bill to some extent, which is to bolster our workers and provide them with union level benefits and healthcare so they can provide for themselves and their families. By allowing CBE exemptions, we would harm workers and deny CBE employees the representation, wages, and benefits provided by a PLA. The amendment's also not necessary. There's no evidence that PLAs reduce or change the number of contractors who apply. In fact, studies show that PLAs do not have any impact on the number of contractors who apply. A 2022 report found that PLAs do not have a statistically significant effect on the number of bidders on a project. Another study also found that projects with PLAs attracted a similar number of bidders and came in at a slightly lower price when compared to projects without PLAs in place. The amendment would also deny CBE employees any PLA protections, while non-CBE workers would be entitled to all the benefits and protections, which is in direct conflict with PLA requirements, which state that projects subject to the PLA law shall bind all contractors engaged in construction on the construction project to comply with the project labor agreement. Therefore, I have several concerns about this. I certainly do understand the desire to get more DC workers in our labor unions and on these projects. I think it's worth reiterating, the first source laws apply to these projects. 51% of workers shall be DC residents. And I do think that for those of us who want to see more DC residents in our labor unions, the PLA law combined with the first source law really helps create that on-ramp because you have 51% of these DC residents on the project who then get to see what it's like to be part of a union and see if that's for them and hopefully continue on. I appreciate the way Councilmember Parker's bill tries to strike a balance here with speaking to concerns that CBEs have and outlining how projects will benefit CBEs as they move forward. And so for folks who are concerned about that particular issue, having accepted Councilmember Parker's amendment as friendly, I believe we have addressed that issue and the need for Councilmember Tran White's amendment no longer exists. I ask members not to support this amendment. Thank you, Mr. Chairman.
Thank you, Councilmember Nadeau. Further on the bill, Councilmember Pinto.
Thank you, Mr. Chairman. I have a question for Councilmember White. So you talked about part of your priority being exempting CBEs from the effects of this bill. Would this exemption apply to all health and safety standards that CBEs are required to follow under current PLA, or is it just limited to the threshold requirement of the bill?
That's a great question. No, it will not exempt them from the health and safety requirements that DC set for all persons on construction projects. It's just exempting from the $50 million threshold we're setting forward today for the DC-based projects over $50 million.
Thank you.
Councilmember McDuffie.
Thank you, Chairman. I want to thank Councilmember Parker for moving his amendment. And I had intended and was talking to Vicky and folks in labor and intended to do a similar amendment. And so I was pleased to support the amendment that he offered. I still have concerns though, and I plan to support Councilmember White's amendment today because I still haven't seen the evidence yet for inclusion of enough DC residents when there are PLAs, especially DC minority residents, Black folks in communities that need and are deserving of jobs. I also believe we can do better as a city to ensure that on projects where we spend the most money, the most district residents possible are included in those projects. I think people need to work now. That's what I hear when I'm out and about and talking to folks who want jobs and need jobs. They want good paying jobs. They want the wages and they want the benefits. And I understand the value of PLAs. I understand the value of organized labor. If you've talked to me before, you've heard me say that I came up in a union household with a mom that was a member of her union in the federal government. My dad was a local labor union leader in DC government as an electrician, and I paid union dues myself as a letter carrier before going to college. And so I know the value of earning a living wage and having benefits, but I think we have gaps in the current PLA law that at the expense of DC residents will favor people who are outside of the District of Columbia. And that's a problem for me. And I've asked and would like to work to be able to, perhaps build up the capacity supply of workers for these various trades in construction. But until we are able to do that, I think it's misguided to lower the threshold, because ultimately, if you're harming CBEs who are high-end DC residents, then what is the impact on our local economy? What is the impact on these communities where these people who are working with CBEs are employed and where they live? And so I don't want to create a tension, but I think there is one that exists. And I think we have to really solve for that. And to be clear, I voted against the last amendment because I didn't see a fiscal impact statement to better understand the cost there. And that was important to me before voting in favor of it. I don't think we understand the full cost of PLAs on district residents, the impact on CBEs. I think the racial equity impact assessment talked about some of it, but until it's clear to me, I'm going to support this amendment that exempts CBEs.
Councilmember Parker and White.
Thank you, Mr. Chairman. Just very quickly, I too want to acknowledge the concerns raised by Councilmember White. We all want to ensure that district residents are first in line for these projects. However, we also want to make sure these projects and the contracts that come from them are good paying jobs with sufficient protections. It is worth noting we just voted or accepted an amendment that would exempt the next 4 to 5 projects in the CIP. And so we have time to figure out and get to the root of the concerns that, again, I acknowledge are valid to a certain extent. Part of the conversations happening behind the scenes is how can we better coordinate with DGS, DOES, labor partners to ensure concerns raised by CBEs are adequately addressed. One concern that I've heard is the burden of investing in health plans and in retirement plans, and the view that some may see the requirements for PLAs as double dipping. That to me is a very valid concern. However, exempting CBEs from PLAs doesn't address that concern. It doesn't also guarantee that more district residents are going to be afforded jobs, and certainly not good paying jobs. A part of what I'm getting at is our work is about effective oversight of both DOES and working across government and with our labor partners to ensure we can secure this deal. I hope we as a council will continue to uphold our commitment to good paying labor jobs, because as I mentioned last time, labor is the reason why we have such a strong middle class here in the district and across our region. And anyone that's promising you to say, oh, just exempt people from that law and everything's going to be okay, I don't think it is backed by history. Last point I would just make is the RIA for the underlying bill points out that the research is unclear around the negative impact to CBEs. And in fact, history shows us that minority groups have fared better under PLA projects. For all those reasons, I hope that we will continue to maintain our commitment to this bill with the amendments that I believe move us towards the concerns that Councilmember White have raised, which again, I acknowledge are valid. But I think missed the mark in addressing the root causes that have been raised. For that, thank you.
Thank you, Councilmember. Councilmember Robert White.
Thank you, Chairman. I want to thank my colleague for offering this amendment, which I've discussed with him that I won't be supporting. I agree. We want and need more DC residents on jobs. My concern, the two primary concerns with this amendment: one, exempting CBEs from PLAs doesn't get us there. We know that because of first source requirements. We are frequently not meeting the requirements to hire DC residents. And a large part of that is folks are saying they're not qualified DC residents. Well, our unions have apprenticeship programs that train these folks so that we will have, I think, fewer exemptions, more DC residents. And I'm also willing to work with my colleagues and hopefully the administration to lean on labor to make sure we are getting DC residents on these projects, because labor is going to ask of us and we have to ask of labor as well. The other concern I have about this amendment is that it creates a loophole. So a large out-of-state company can create a CBE subsidiary and be exempted from the PLAs. This creates a circumstance where you still end up with fewer DC residents working on jobs, fewer residents going through apprenticeship programs. And as folks know, I'm very keyed in to our trades. It's one of the reasons that I recently introduced a vocational education bill, because it's time for a massive expansion of vocational education. This is something our unions are doing, and I work with labor to make sure they would be included in this work. But if we want to see more DC residents working on projects, that means we need more of them trained. We want more of them trained. It means we're funding that through unions that are doing the apprenticeship programs. And it means that we are leaning on unions to say we expect when they're PLAs that they're going to be DC residents on these jobs. So I think there's a common concern, disagreement about how we get here. So I appreciate the amendment, but I won't be supporting it. Thank you, Chairman.
Thank you, Councilmember. Councilmember Fruman.
Thank you very much, Chairman Mendelson. I too am not supportive of the idea of what I would call a sweeping exemption for CBEs in this setting. CBEs can apply for the contracts in a PLA context, whether or not they're union or not. They can, but once in, they're subject to the requirements of that PLA. And the question then becomes, what is it about those requirements that may be an unfair burden on CBEs? And I think this goes to something that Councilmember Parker was talking about. We should be looking at, are there real things in that setting? One possibility is the healthcare obligations. If a CBE was providing healthcare and then they were required somehow to have their workers come off of that healthcare and go on to a union healthcare plan, you'd have to wonder about that. But my understanding is in the vast majority of cases, the way that it works is those workers have the opportunity to either stick with their healthcare plan if it's an equivalent, or go to the union plan. And so we can address that kind of thing. What happens when there are pension contributions and the pension contributions are associated with that worker? But what happens if that worker doesn't vest in those eventually? How do you deal with that sort of issue? I think we should be looking at those kinds of issues to make sure we're not creating undue burdens for our CBEs while we're expanding the universe of workers who are subject to the protections of PLAs, which will benefit all of our workers over time. So it's not that our current system is perfect. We can be focusing on how we refine it. But in the meantime, I'm fully supportive of expanding PLAs to contracts that go down to 50 million.
Thank you, Councilmember Fruman. Councilmember Trahan-White for second round.
Yes, thank you. I did want to make a comment. I don't think that one bill or two bills or 10 bills fixes all of our issues as relates to employment and getting people to work in the District of Columbia. So I don't think that narrative is a fair narrative in discussing opposition to this bill. What I do know is that in practice, we had a Ward 8 company who applied to be on a Ward 8 project, and did not get win the bid. And as a result, when I went and looked in further, who did get it was a company from Sterling, Virginia. And I know the Ward 8 company because I often refer people to them because they have an apprenticeship program in DC, in Ward 8, that hires people from DC. So in practice, we are able to see progress in DC residents getting hired personally, because that's what I see myself. I don't know who this Sterling, Virginia company is hiring. And in that vein, and when I talk to a lot of the union shops, and I think they have great intentions. I think they want to do a whole lot. I just haven't seen where they moved the needle and doing more work in DC. I asked you, where's your apprenticeship program? Laurel, Maryland, Upper Marlboro, Maryland. With the amount of resources that they have, they should have stronger apprenticeship programs that we all know about and are supporting and filtering DC residents through. And I just haven't seen that commitment in the last 5 years. And so this is not a silver bullet. This is just an effort to have inclusion, if that's what we're really trying to do, and ensuring that not just our residents, but our local businesses. And we heard someone make a comment about CBEs, and as it's written, CBEs are independently owned, operated, controlled by more than 50% owned, operating, controlled DC-based enterprises or not-for-profit businesses. What are the requirements? More than 50% of the employees of the business are residents of DC. The owners of more than 50% of the businesses, enterprises are residents of DC. I have 30 more seconds, Chairman.
No, because this is the second round, you have 2 minutes. So if you could just wind up quickly.
I never heard that in my life. More
This
than
is
50% of
second
the
round.
assets
You
of the
have 2
business,
minutes on second round.
excluding bank accounts. My point is that by law, and that there are those who circumvent the law, but by law, these CBEs have to establish a true commitment for 50% or more of their businesses, including ownership in DC.
Thank you, Councilmember. I'm going to urge members to not support the amendment, and I associate myself with the remarks of Councilmember Nadeau, where she went through a number of reasons why this amendment is problematic. I would like to add, though, that we have had project labor agreements on a number of projects over the decades in the district, about which there has been no complaint. And we've required a PLA on every project over $75 million for a number of years, including, because I remember this was part of the fiscal impact statement, the hospital at St. Elizabeth's. No complaints. I want to emphasize that the experience with PLAs has not reflected the concerns and objections that have been raised in this discussion. The concerns and objections that have been raised in this discussion, I think fundamentally have at their root businesses that do not want union work. That's what this is about. When I say this, I mean the objections. It's about, I was talking a week ago with a CBE who I have a high regard for, does great work. You don't like PLAs. I said, well, why don't you just get your members to be, your employees to be a union? He said, well, they don't want to. When I first ran for office, I wanted a union printer. I looked for a union shop in the district. It was a 2-person shop and they were a union. So a small business can be a union, a big business can be a union. This is a choice whether they want to be a union or not. Now, we have laws regarding first source. So when we talk about whether DC residents are hired, that has nothing to do with PLAs. That has to do with our first source law. So that issue is being conflated here improperly. And same with the CBE requirement, which is a requirement in the law. All those requirements still pertain whether it's a PLA or not. But I don't recall complaints about South Capitol Street Bridge or the Convention Center or any of the schools that have cost over $75 million and have been PLAs. I haven't heard those complaints, other than when we have this kind of legislation before us, where businesses that really don't want to be union come in and they give us all the reasons why this is horrible. Experience shows otherwise. I do not support this amendment, urge others not to support it. If there's nothing further on the bill, excuse me, on the amendment, the vote will be on Councilmember Trayon White's amendment.
Mr. Chairman,
Yes, Councilmember Parker.
just very quickly,
Second round.
very quickly. It's more of comment. I just would encourage us not to dismiss the valid concerns that have been raised by Councilmember White. I plan to vote against his amendment and I plan to support the underlying bill, but I think he brings to the surface very valid concerns. And I think we do a disservice to merely dismiss it as fodder for those opposed to unions.
Thank you. We have the amendment before.
Chairman.
That was not a pause to invite more debate. Yes, Councilmember McDuffie, second round.
Yeah, just briefly, I think we would do well as a city to really address the issues and the tension that exists when it comes to these issues, and not to dismiss the real legitimate concerns raised by our local small businesses. I support what organized labor is doing and attempting to do, but we also cannot ignore the gaps in opportunity that exist within organized labor, particularly as you get to some of the higher paying jobs within the construction trade. And we also must recognize, as I understand it, that union representation is below the national average in DC, and ask ourselves why that is. I think it does have something to do with, not having as many opportunities to pursue the trades, particularly inside of schools like used to be the case. And I'm one who had the benefit of a father who attended DC public schools and graduated from Bell Vocational High School, and had a job when he finished as an electrician. So, we've got a ways to go in terms of trying to address these issues within the trades when it comes to construction and otherwise. But we also have a ways to go to closing the racial wealth gap. And one of the primary ways that we do that is through entrepreneurship, business creation, and these CBEs are trying to do that. And if we are burdening them with additional costs, we're also costing small businesses and the community ultimately. So I think Matt Fruman had it right. I just wish that we would not vote in favor of this before we fix that issue.
Thank you, Councilmember. We have the amendment before us by voice vote. All those,
Roll call, Chairman.
Madam Secretary, would you call the roll? It's on Councilmember Tran White's.
Councilmember Robert White,
No.
Councilmember Robert White votes no. Councilmember Trahan White,
Yes.
Councilmember Trahan White votes yes. Councilmember Allen,
No.
Councilmember Allen votes no. Councilmember Bonds,
No.
Councilmember Bonds votes no. Councilmember Fruman,
No.
Councilmember Fruman votes no. Councilmember Gray is absent. Councilmember Henderson,
No.
Councilmember Henderson votes no. Councilmember Louis George,
No.
Councilmember Louis George votes no. Councilmember McDuffie,
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
No.
Chairman Mendelson votes no. Councilmember Nadeau. No. Councilmember Nadeau votes no. Councilmember Parker.
No.
Councilmember Parker votes no. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Mr. Chairman, there are 3 yeses, 9 nos, and 1 absent.
Thank you, Madam Secretary. The amendment fails. We have the bill as amended before us. Is there any further discussion? Hearing none. Can we do a voice vote on the bill? Yeah, Councilmember Bonds, did you want to be recognized?
Yeah, I do want to be recognized because I think we are headed in the path of continuing what we always do, and that is to to limit the discussion in such a way that we disenfranchise part of our community. And I think we have to, while I'm in agreement with the action we just took, I think we have to find a way very quickly to talk about the divisions that we have. And the divisions affect the neighborhoods. I'm just going to be very honest with you. And while I may be strongly pro labor, I'm also pro all of our workers in our community. So I think it's time that we come together and look anew We're looking anew at how we, I guess, sort of revise our economic engines within the city. And so what we're really talking about is money. We're talking about who's going to be on first, who's going to have the opportunity to work and how they're going to work. And I'm telling you now, if we do not include DC residents, and I know how the union process works, also am aware of what 51% means. If we are not genuine about that, we're not going to see the kind of return that we need. We're talking about the people in DC. They also deserve an opportunity to have a good life. And that's all I wanted to say. Thank you, Mr. Chairman.
Thank you, Councilmember Bonds. Is there further with regard to the bill as amended? By a voice vote on the bill, all those in favor of Bill 25-469 as amended, say aye.
Aye.
Opposed?
Chairman Markby is present.
Councilmember Tran White will be marked as present. The bill is approved unanimously. The next measure is Bill 25-119, Healthy Homes and Residential Electrification Amendment Act of 2024. Again, this is a final reading reported out of the Committee on Transportation and the Environment. Councilmember Allen.
Thank you very much, Mr. Chairman. Should I wait a minute?
Sure, why don't we give a little pause? If we could have order in the chamber, Councilmember Allen, you have the floor.
Thank you very much, Mr. Chairman. I am excited that we are about to hold our final vote to pass the Healthy Homes Act, a bill that is critical to the district's efforts to mitigate climate change broadly and improve indoor air quality for about 30,000 households, mostly our low and moderate income neighbors. It fits into the district's broader framework of moving away from fossil fuel use to electrification. They can be powered by renewables, and this bill in particular is focused on ensuring we don't leave any families or homes behind. Nearly a quarter of the district's energy generation comes from gas, and almost half of the district's households rely on gas for home heating. The combustion of natural gas releases harmful byproducts, which can increase the odds of children developing a respiratory illness by about 20% and asthma by about 42%. The data is clear. To meet our climate goals and to improve the health and wellness of district residents and to reduce the negative impacts on our environment, the district must eliminate the use of fossil fuels and transition towards sustainable energy. Under this law, DOEE will be required to complete 30,000 residential electrification upgrades for low-income households with interim benchmarks that increase over time. So we're talking about high-efficiency heat pumps, electric appliances, and more that are going to reduce energy usage and improve air quality. And I want to be clear, participation in this program is perfectly voluntary. So I'll reiterate again, nobody from the district government's going to come take your gas appliance away unless you ask them to. But if you're a low-income resident, it can be done for free. I want to thank the Sierra Club's DC chapter, Washington Interfaith Network, the DC Environmental Network, Washington Interfaith Power and Light, the Chesapeake Climate Action Network, the NAACP DC chapter, and the incredible community of environmental activists and residents that have helped ensure that DC residents and children especially are going to grow up in healthy homes. Finally, I also would like to once again recognize the incredible work of Christopher Laskowski, our late committee director, who helped craft this bill, along with so many others. that I believe are going to materially improve lives of DC residents. With that, Mr. Chairman, I move this for our final reading.
Thank you, Councilmember Allen. We have the bill before us. There's an amendment from Councilmember McDuffie.
Yes, thank you, Chairman, and thank you, Councilmember Allen. I am moving, as was discussed earlier during our breakfast, an amendment that would require the Department of Energy and Environment to develop a plan outlining how they will provide a written estimate or explanation to each program recipient. And this explanation would detail the estimated difference in the annual energy cost between electrification and the recipient's current energy source. Obviously, don't want this to be construed as not supporting the underlying benefits and the retrofits for a more sustainable and healthy power source. I just want the district to be upfront with its residents and customers who are receiving this retrofit that there may be some cost changes to their utility bills. This really meant to make sure that there's a fully informed process that the OEE will be laying out for residents, and I hope it's going to mitigate some of the concerns my office have had about the cost for moderate and low-income residents to these changes. And we did, after discussion at breakfast this morning, work with Councilmember Allen and his team to modify the amendment, striking part of the rationale, and hopefully it'll be accepted as friendly.
I don't have something in front of me. So what is being accepted?
It was recirculated, but essentially, if you have the old version, it strikes everything after the first two sentences. So everything beginning with the United States energy information. What time are we recirculating?
And Mr. Chairman, we just want to speak to it briefly, then I'll accept it as friendly.
Hold on a second. What time was it circulated?
11:15, 14.
Okay, so the amendment, which is with regard to the rationale, we should reflect the version that was circulated later, which I assume that it's the revised amendment that will be on limbs. Councilmember Allen.
Thank you very much, and I appreciate the work here. In conversations with the Department of Energy and Environment, the type of information here that this amendment would require was part of what were intending to do. So they don't see any problem with adding that language in, and neither do I. I think it will be helpful and important. We always, obviously, this is a voluntary program, so people are going to be signing up to join it. So we want people to know, obviously, the benefits that they're about to receive from enrollment and transitioning away from fossil fuels. And that education, I think we'd all agree, is critical, and we want to have that. DC families are going to benefit from this. Right now, the estimate is they will average about $372 in savings per year for that efficient electrification of their homes. And the Department of Energy and Environment estimates, after their analysis, that homes that participate in this will see a range from $210 savings per year to $667 savings per year. You add on top of that DOE's Solar for All program, and you're talking about $1,100 in savings that households will be able to benefit from. And in addition, by making this transition, and this should be part of that summary that those participants are going to get, is that they will not be subject to the increased cost that Project Pipes will put in place, which estimates about $1,000 more per year in utility costs. So all told, by being able to eliminate the Project Pipes cost of about $1,000 increase per year, and then up to $1,000 in savings per year, we're talking about real savings and costs for our families. And so I think DOE will be great to share that information with folks, and this gives the opportunity to make sure DOE will be able to share all of that with folks right up front. So I appreciate that, and Mr. Chairman, I accept the amendment as friendly.
All right, in order for it to be accepted, there has to be no objection. Is there any objection to the amendment? Hearing none, it's accepted. Further on the bill. We are going to vote on Bill 25-119 as amended. All those in favor say aye.
Aye.
Opposed? The ayes have it unanimously. The next measure. The next measure on the agenda is final reading on temporary bill 25-774. Relief for River East at Grandview Condominium Owners Temporary Amendment Act of 2024. Councilmember Robert White.
Thank you, Mr. Chairman. In 2016, 46 households bought condos at River East at Grandview. Many of these households were led by Black women who became homeowners for the first time using the district's home purchase assistance programs. Others were retirees, recent graduates, young couples, veterans, parents, and parents-to-be. These units were funded by a Department of Housing and Community Development loan to developers to build 46 affordable housing units on Talbot Street in Ward 8 for ownership. Each followed the path they thought would help them and their kids lead better lives with more stability and financial growth. In August of 2021, their dreams almost literally came crashing down. The new owners were told their new building was on the brink of collapse. So after years of saving up, filling out paperwork, and closing on their dream homes, they had just 2 weeks to evacuate. Since the evacuation almost 3 years ago, River East at Grandview owners have worked diligently to untangle the tremendous financial, legal, and emotional web they were thrown into. It has been heartbreaking to watch. In addition to the strain on families, the disappointment of parents who had to tell their kids that they had to leave their new bedrooms, this saga has caused many residents severe depression and significant damage to their credit ratings. My team has worked diligently with DHCD to help these families. Last month, the council unanimously passed emergency legislation to support River East at Grandview homeowners. At that time, the administration had a few additional supports intended for the owners that they needed more time to complete. My team and the administration worked over the past month to get these across the finish line. The first of these supports was tax relief. This had a cost which the administration agreed to transfer, but they needed more time to reprogram the money. The OCFO finalized that reprogramming over the past few weeks, so it was ready for second reading on the temporary legislation, and our budget director confirmed this transfer at the council breakfast this morning. The second relief was to give owners priority on wait lists for other DHCD programs. The current legislation says owners get priority on wait lists for inclusionary units. Over the past month, DHCD and DMPED worked with my team to finalize language that gives River East owners priority on more wait lists, such as for affordable dwelling units and other DHCD-funded properties. Lastly, the Office of the Attorney General and the Office of Tax and Revenue within the OCFO provided additional recommendations to make sure the specific language and citations in the bill met the intent. The amendment in the nature of substitute I'm moving today incorporates all of these changes. I would also like to note that DHCD has already begun to implement the emergency measure from last month. They have drafted a contract for their work with NACA, sent letters to owners about a rental option by the May 1st deadline. Now 30 more seconds, Mr. Chairman.
Without objection.
And sent notice to the owners ahead of the May 15th deadline, confirming that the mayor will relieve their existing HPTF and HPAP loans and the amount of that relief. There's still a lot of work to do to make sure each owner has what they need to move forward, but it's good to see this progress. Because of the damage done to these families and changes in the market, including higher interest rates and more expensive housing, this is not a perfect solution. I hope this also is a flag to the administration to focus more on enforcement of the condition of housing with housing built with taxpayer money. With that, Mr. Chairman, I want to thank my team, particularly Senior Legislative Counsel Caitlin Kachalova for their work on this issue, and I move the amendment in the nature of substitute to the Relief for River East at Grandview Condominium Owners Temporary Amendment Act of 2024.
Thank you, Councilmember White. So we have the amendment nature of a substitute before us. Is there discussion?
Yes, Chairman.
Councilmember Tran White?
I want to thank my colleague Robert White and him and the staff for his diligence. We similarly work with you, Chairman Mendelson, to create some relief for these residents, of which are all people of color, of which most are first-time home buyers, of which are first struggling to stay in the district. We know that what happened was an atrocity to their income, but also to their family and stable living conditions. Many have moved out. Many have to shift their kids from their current school to a new school, depending on where they live. But the reality is that DC has to take some ownership in correcting this wrong. I think that we have taken some steps to shore up, but we can do a whole lot more. Residents are crying out for equity and inclusion, and they've done the steps we asked them to do, going to HPAP, going to our programs, to our classes, getting into a home. But to shore up that they have this, something to come back home to, we haven't quite figured that out yet. And I think that we have to encourage not just our colleagues here, of course, but the executive branch to do more to undergird and just show stability for these residents who've, the pot of money allocated them to stay where they are have ran out. And even the money to keep their board vibrant, to communicate with each other, to organize is also in jeopardy as far as paying for legal fees. And so I'm concerned. I want to thank my councilman colleague Robert White for this measure. But again, we have to do more to ensure that we can put some more protections around these residents and have something for them to come back home to. Thank you.
Thank you, Councilmember. Further on the bill, the amendment nature of a substitute? On the amendment nature of a substitute, all those in favor say aye. Aye.
Aye.
Aye.
Opposed? It's approved unanimously. We had the bill as amended before us. Is there discussion? On the bill as amended, we'll have a voice vote. All those in favor say aye.
Aye.
Opposed? The ayes have it unanimously. The next measure, we're now at emergency bills. Unlawful restrictions in land records declaration resolution of 2024 being moved by me and Councilmember Fruman. This is the declaration. It is to enable consideration of the emergency bill, which would put into effect more quickly the permanent bill that went through first reading earlier today. This has to do with adopting the uniform law with regard to unenforceable covenants, but also to as a matter of public policy, render void any covenants to conflict with zoning and that predate the Zoning Act of 1938. I move the declaration. Discussion? Councilmember Bonds.
Mr. Chairman, I just want to make sure that this is for the Cherry Chase community, or is this for any restrictive covenant? Because it's been brought to our attention that there are numerous restrictive covenants across the city.
I, of course, don't have the text in front of me, but I believe the bill is identical to the permanent bill, because that's what the notice says. And the permanent bill speaks to any covenant that conflicts with zoning, the zoning regulations, and the covenant was put in place before adoption of the 1938 zoning act.
All
So
right,
it's citywide.
all right, thank you.
Further on the declaration. On voice vote or roll call? Ash, voice vote or roll call? We'll have a voice vote on the declaration. All those in favor say aye.
Aye.
Are there any opposed? The ayes have it unanimously. The underlying bill so moved. Is there discussion?
Mr. Chairman, I wanted to hear the date that you mentioned to Councilmember Bonds.
I said 1938.
Oh, okay.
You're gonna make me look.
Yeah,
I don't know if I-
previously you had said 1938 when we
I've
were
been saying
discussing
that
the
rather
permanent bill.
consistently.
So it applies to those before, but not after.
Correct,
Yeah, that's it.
correct. The idea is there are two steps to the voiding. One is that it conflicts with the zoning, and second, that it predates the zoning regulations.
So what would a person who has a restrictive covenant on their home after 1938?
Well, now, if it is a illegal covenant, such as a racial covenant, then there's a different provision in the bill that applies there. That covenant is already, I'm thinking like a racial covenant. And I have a hunch you're thinking of a covenant that might have been put in place in, let's say, 1948. That covenant is unenforceable by case law. And the uniform part of this bill says that you can file an amendment that would have the effect of excising it not literally excising it, but excising it from the deed. That's in the uniform part of the bill.
Okay.
That answer your question?
It does. It does. I actually,
You're gonna make me go look at the report again.
I don't think you need to look at the
So
report.
there are two parts to the bill.
Mhm.
The uniform law was adopted by the Uniform Law Commission, of which the district has membership, that says, hey, there are these void covenants, such as racial covenants, religious covenants, and there are people who want to get rid of them. They don't want them in their deeds. And the uniform law speaks to a process for doing that. We not only are adopting the uniform law, but adding a provision that says that you can record this document in the land records as an attachment to your deed at no cost. The second part of this bill comes from what Councilmember Fruman had introduced, which speaks to these covenants that are not void. However, they conflict with zoning. And what the bill says is, as a matter of policy, the public policy in the district is that those covenants are not enforceable. If one, they conflict with zoning, and two, the covenant predates the zoning regulation, the Zoning Act of 1938.
Appreciate that background. I'm one of the people in the District of Columbia, my wife and I, who happen to own a home that has a racially restrictive covenant on it. And we'll be taking the steps that you all have outlined that we're voting on today to get rid of it. But it was a racially restrictive covenant put in place by several residents who owned homes on North Capitol Street in a unit block of Evar Street back in 1946. That said that the parties mutually agree and promise that they should never be used, that the property should never be used or occupied by or sold, conveyed, leased, rented, or given to Negroes or any person or persons of the Negro race or blood, was part of the language reference in this racially restrictive covenant that I dug up while doing some research. So I appreciate that Councilmember Fruman introduced this measure and that the committee of the whole under your leadership has worked to bring this to the full council for a vote. And I am definitely in full support of it.
So I'm looking at the committee report. The uniform law addresses how land records containing unlawful restrictive covenants are treated in practice. So we're talking about, for instance, the covenant you just read. While on the surface, the aim of the law is to remove or delete the offending records. For a number of reasons, excising the covenants would be impractical or have legal ramifications. In response, the uniform law removes, quote unquote, removes the covenant by allowing property owners to record an amendment to a land record to clearly eliminate any purportedly continuing effect on the title. And then the committee print of the bill, and therefore the emergency as well, adds a section that waives any fees for releasing unlawful restriction from a deed or otherwise governing document by an owner.
Thank you, Tim.
Anything further on the declaration? No, we did the declaration. Anything more on the bill? Voice vote on the bill, Bill 25-809. All those
Mr.
in favor?
Chairman?
Yes.
I'm sorry, this is Brooke. Can you record me as voting yes on the declaration as well?
Always a challenge.
Sure.
You
Motion
know,
to reconsider?
yes, Councilmember Nadeau just moved to reconsider the declaration, even though we're in the middle of the bill. If there's no objection, we'll reconsider the declaration. Hearing no objection, the declaration is before us. We will do the vote again unless there's discussion. All those in favor of the declaration say aye.
Aye.
Any opposed? The ayes have it unanimously. Madam Secretary, are all the members present as well as virtually present? Counted? Okay. I believe that's 12 members.
Thank you very much.
The bill, so moved. The bill's before us. All those in favor of the bill, that's Bill 25-809, say aye.
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 Opposed? The ayes have it unanimously. This is work. All right, we are now at Lafayette Elementary School Grass Field Emergency Declaration Resolution of 2024. Councilmember Louis George.
Thank you, Chairman. On Thursday, I circulated emergency resolution concerning lower field at Lafayette Elementary School in Ward 4. This March, with next to no notice given to the community, DGS announced they would be replacing the field with artificial turf, reneging on the prior commitments to repair and maintain the existing natural grass field. The community was blindsided by this decision and has every right to be concerned. DGS complied with DC statute by the skin of their teeth, only holding community meeting to discuss turf after repeated insistence from ANC 34G in my office, a meeting which was held the same day they announced their decision to the public without any of their input. These actions were called out by ANC 34G, who issued 2 resolutions, one in February and one in March, demanding DGS live up to its commitments to community members. Since this decision was announced, I've received an outpouring of concerns in the form of multiple meetings with community members, constituent emails, phone calls with the community and ANC commissioners, and a survey conducted by the ANC Commission. They have the right to be concerned. Artificial turf has been linked to forever chemicals like PFAS that pose serious health risks. Evidence has increasingly exposed the health risk of artificial turf, and cities like Boston have gone so far as to ban the installation of any new artificial turf citywide. DGS has justified their decision by denying the health and safety risk of artificial turf, but these claims are not supported by scientific evidence. According to the EPA, the more we learn about PFAS chemicals, the more we learn that certain PFAS can cause health risk even at very low levels. There are physical concerns too. There's evidence to show that certain injuries are more serious on turf fields, such that every professional sports team in the district plays on a natural grass field. Worse yet, these risks will disproportionately impact the kids who play on Lafayette Field every day. DGS used cost savings as a part of their rationale, but evidence calls this into question too. The Budget Office Fiscal Impact Statement made it clear that over the 4-year financial plan, a grass field is $300,000 cheaper than an artificial field. Additionally, DGS's projections of needing to replace grass fields every 2 to 3 years are contradicted by the testimony we've heard from the Sports Field Management Association, who have reported replacement being needed as rarely as once every 24 years when proper maintenance is done. My measures will hold DGS to the commitments they've repeatedly made and will uphold the overwhelming wishes of the community for a natural grass field. We can't threaten our kids' health by exposing them to toxic chemicals on a daily basis. And while we aren't scientists, so we will have to see how this evolves over time, we are public servants who owe taxpayers a fair and transparent government response. I urge you to vote in favor of these measures today, and thank you. With that, I move the emergency declaration resolution.
Thank you, Councilmember Louis George. Is there discussion on the declaration? Councilmember Fruman?
Thank you very much. I want to thank Councilmember Louis George for coming forward with this resolution. I want to be clear that from my perspective, I don't think we should foreclose the idea of having artificial turf fields anywhere in the district at any time. I do think technologies around artificial turf fields have been evolving and the safety issues are changing all the time. There's a number of fields where every time it rains, where it's a natural grass field, every time it rains, it gets torn up and then it becomes dangerous in a different kind of way. So I don't want this vote to be perceived as a prohibition or a step towards a prohibition on artificial turf fields writ large. I think we need to do a lot more thinking and talking before we would do something like that. But in this particular context, to me, the issue is the process issue and the way in which this has been presented or not presented to the community, a fait accompli, where there is such uniform concern about it. I think we can't let the administration go forward and just go ahead and put an artificial turf field here, given the record that's happened here so far. But I do want to be careful not to be suggesting that artificial turf fields are in and of themselves bad, or there may not be places where they make a lot of sense.
Thank you, Councilmember Fruman. I'm going to speak against the declaration. I had hoped that this matter would be put off, and I reached out to the mayor, but obviously that's not happened. So there seem to be two arguments that are used in support of the declaration. First, that this is what the community wants, and second, that there are health hazards. Let me speak to this latter first. With regard to the health hazards, PFAS has been around for decades. According to the Centers for Disease Control, and I'm looking at a fact sheet, the PFAS fact sheet that's available online, quote, human health effects from exposure to low environmental levels of PFAS are uncertain. Finding a measurable amount of PFAS in serum, that would be blood serum, does not imply that the levels of PFAS cause an adverse health effect. So yes, there are some residents who are arguing rather forcefully that there are serious health concerns, but CDC does not agree, and this is being researched. If the concern is that the community doesn't want this, which is a different argument, I'm concerned that we would that the council would be spending its time figuring out an individual field, and that what the government is doing is suddenly going to be upended. So the mayor sent me a text in which she said, if the legislation passes, we would have to halt the project and negotiate change orders to convert from turf to grass. Now, I'm looking at an email from DGS to Councilmember Louis George. It says that a turf field costs about $650,000 and the annual maintenance is $23,000. The natural grass costs about $250,000. That's $400,000 less. The maintenance is $54,000 annually. That's double. However, the useful life of the turf field is 10 years and for the grass is 2 to 3 years, which means that in 9 years, it will have cost more than the turf field cost. So the turf in the long term is the more economical approach, and I often argue that we should be looking at what is the most efficient use of dollars. And then I have this letter that was sent by both the Chancellor of DCPS, since DCPS is involved, and DGS. This field is heavily utilized. The new field needs to hold up to rigorous usage demands, as the park is frequently used by DCPS for regular activities, by DPR for organized events, and by the community. For grass fields, best practice is to allow them time to recover. However, here this is impossible because the field is not fenced in to restrict access during the winter months. In other words, unless the grass fields are protected, they will degrade quickly and need replacement. And the mayor mentioned to me that one needs to look no further than the Hearst Recreation Field to see an example of where the grass has become basically a mud field. So I would rather that this was put off for a month and worked out, but that doesn't seem to be the case. And the health effect is not so conclusive. CDC doesn't recommend against PFAS. And the cost is in favor of what the executive is proposing. And this will probably, if this is adopted, this will probably be a mess in 2 years or 3 years. So I won't be supporting it. I went over my time, but nobody objected. Councilmember Tran White. Did you want to be recognized?
Yes, I guess my initial question to Councilmember Louis George, is this going to affect all fields in the district or just this particular field that you're fighting for?
It's just narrowly tailored to Lafayette Pointer Field.
All right, thank you for that. And follow-up question, I was looking at an article that was in the Washington Post in March of 2024 for the PFAS and its potential risk, and I just want to read this real quick. PFAS, dubbed forever chemicals, they did an analysis on a field of kids playing soccer in San Diego. And doing this analysis, they took some results on the kids, and I'll read it as such. Turf advocates and other scientists say there's no reliable evidence showing that PFAS and turf pose a risk. Proponents also say that such synthetic fields require less water than grass, don't need pesticides, and allow for more frequent competitive play without potholes, mud pits, and needing tending to as other fields. Test results from this showed that they found 2 of the 3 players, including Pavinian's daughter, Emma, came off the field with higher amounts of PFAS on their hands than the other beginning in practice. So did Pavini. When the other players practiced on the national grass, the result was mixed. 2 of them had a decrease in PFAS, while Pavini was found to have more PFAS. The new soccer ball also had detectable amount of PFAS before they were even used on the field. And so there's been a lot of mixed reviews and conversations about this. And in closing, Chairman, I did reach out to try to get some information from DGS, and they noted that to my point this morning, that Councilman Murray Che passed legislation to keep us from creating fields with harmful chemicals. And, you know, fields have evolved over time. We even took some fields up. And so what I read is the crumb rubber infield is basically recycled crushed rubber from tires. Some groups claim to be hazardous, but there has been no real proof of its hazardous material. Scientifically supporting the link crumb rubber fields to cancer. It is used all over the country, and it's also used in the NFL. And so I don't know what articles or evidence is back at this moment. And so I'm just trying to get more information and clarity.
Thank you, Councilmember. Councilmember Parker?
Thank you, Mr. Chairman. I do have a couple of questions, but first I would say I would be remiss if I didn't just acknowledge in Ward 5, we have legit chemical plants operating in parts of our ward that community members are calling attention to. So as we move forward, I do want us to just remain committed to this issue on behalf of residents across the city. For me, as has been raised, I have questions around the health impacts, but I do think there are process issues here that are very valid and worth us leaning in on. It is my understanding that DGS committed to this community, the school community and the broader community, that they would install grass. It is also unclear of the extent of DGS's engagement with the community, that there were required steps that they failed to take. And so I think on that point alone, in addition to the fact that we say we give great weight to ANCs, it is my understanding that all of the commissioners in this area have weighed in to say that they do in fact want grass. My first question is around cost. And this may be better suited for our budget director, given that this is an emergency. The inherent suggestion is that there isn't a cost, yet Chairman, you're referencing a letter from DGS and DCPS highlighting a significant cost. Can we just square those two things?
I was not paying close attention. Square.
Well, I will repeat.
The project was already
And
funded.
this is Budget Director Budoff. Can you justify, explain, speak to how you came up with approving the emergency, given that the chairman is citing significant cost pressures from DCPS and DGS?
Yes. When we do a fiscal impact, we look at the cost over a 4-year period. So the 4-year financial plan. And within the 4-year financial plan, the costs are roughly equivalent, if not slightly less, for a grass field. The chairman was referencing the long-term costs of the upkeep and maintenance and eventual need for replacement or more regular replacement of the grass fields, but within the 4-year financial plan, there are no additional costs.
Got it. I think that's an important point. I have full faith and confidence in our budget team and our budget director in particular. And it is important to note that DCPS is pointing to cost over the life of this field versus the creation of or the implementation of the field. And then my second question is around engagement, and this is to Councilmember Louis George with DGS. What engagement, if any, have you had with them more recently that this is now becoming a big fight between the council and the executive?
As of today,
I'm sorry.
as of today, I've
To-
heard from DGS today about the issues that the executive has with this.
Got it. And I think that's another important point, that if this was so very important and urgent, DCPS and DGS should have reached out in advance. So thank you, Mr. Chairman.
Thank you, Councilmember. Further, Councilmember Allen?
Thanks. I just want to make a couple of quick comments. I am going to support my colleague. I do think though, and I think I heard this from a couple of colleagues, we do have artificial turf fields. And I think there's many instances when they are the right call to make. We've got, especially with the newer generation of some of the turf fields, I believe they're using much more organic material, environmentally sustainable and supportive material. So I do think there are artificial turf fields that are not a health hazard. And I do think there's a distinction between some of our initial turf fields that the city probably built. And I think that's the reason why back in 2018, that crumb rubber was banned and things like that. So I do think there's a value to that. I do think though, hearing from our ANC commissioners, council member, and hearing from so many community members, they clearly have a preference for this to be a grass field. Listening to the budget numbers, that a grass field's replaced every 2 to 3 years. I've been the Ward 6 council member for 10. I can't think of a field in Ward 6 that's been changed out every 2 to 3 years, let alone maybe once. So forgive me if I don't necessarily believe that's the real schedule that we see in real life. So I would prefer if there was a way that the executive and the council and the neighbors were able to work this out so that there was a not having to vote on emergency legislation. I agree with the chairman. It does give me some pause around having to use emergency legislation through the council on a specific field. That said, I'm still going to support my Ward 4 colleague and the ANCs that have weighed in on this. And I guess I would hope that it had been worked out in advance to try to find some consensus around this. But I also don't want our vote to be taken as one that is against the occasional times that an artificial field makes the most sense. There are times when a heavy utilized field, an athletic field in particular, needs to or can be better suited as artificial turf. Thank you, Mr. Chair.
Thank you, Councilmember Allen. Further,
Yes.
Councilmember Bonds.
Thank you very much, Chairman. I certainly appreciate that my colleague is speaking up for her community. But my question is about this emergency process. I know that we're knee deep into the budget process. And so I just wonder, how did this become the issue that it is today? And whether or not this should have or could have been an issue, let's say, last month, which could better inform us as we're thinking about the budget. We still have time, of course, to work on the budget, but I'm just curious about how it's flowing. Thank you.
Absolutely. As you know, I talked about this. The ANC first did their first resolution in February. We have been trying to solve this issue since February, without having to move legislation since the decision was announced as well. DGS has largely refused to engage with us and has been sort of totally out of touch about it for the past week, but also totally not engaging with the community. And so when the meeting came to have a discussion with the community, it wasn't a discussion. It was this is what we are going to do versus this is what, let me hear what you would like us to do. That's how it evolved as this over time. We funded this in last year. So the work is beginning, which is what makes it an emergency, because the work has started to begin on the upper field where we're dealing with the soil erosion. And so as the work is beginning right now to have them started and put an artificial field in when the community hasn't settled on it is sort of why it's in an emergency space that it's in. And I totally agree with your concerns, and it would not be here if the negotiations with the community, with the ANCs, with the associations and myself had gone appropriately and fruitfully as it should have been.
Thank you very much.
Since this came up, I'm gonna speak to this, so 2 minutes.
Oh, you didn't give me my chance.
What?
No, go ahead. I didn't have a chance to rebut.
I didn't recognize myself. I'm just gonna speak for a minute. So there were some questions on the cost. So this is the table I'm looking at that came from DGS. It's an email from DGS. The installation cost of turf is $650,000, for natural grass, $250,000. That's $400,000 less. Maintenance cost is $23,000 annually for turf, $54,000 annually for natural grass. That's assuming that they actually do the maintenance.
Correct.
The safety risks, turf is a heat island, risk of injury. On grass, must avoid use of pesticides, risk of injury, at risk of drought. The length of useful life, 10 years for turf, 2 to 3 years without closing in cooler months to let grass recover. So I was wrong when I said 2 to 3, it's 2 to 3 years if it's not closed. Usable time throughout the year, turf is usable year round, natural grass is usable April through maybe November, because then it closes.
Wait.
Now, there was a comment or question about contact. So this was a table that was sent by email on April 24th from DGS, April 23rd from DGS to Councilmember Louis George's office. The Chancellor and the Director of DGS wrote together to Councilmember Louis George on April 2nd. And that's where I read earlier, first, this field is heavily utilized. And so that speaks to whether them in context. And then I called the mayor today and I read from her text that she says that they would have to do a change order. And I know subsequently she called the council member. Any further? You look like you want second round, Councilmember Louis George.
Yeah, I want to make it quick because we've been here for long enough. Just a few things. I know you all spoke to the fact sheet. I want to go tit for tat here regarding that. I just wanted to note that the CDC's fact sheet is a year older. EPA fact sheet is actually, Environmental Protection Agency is actually more recent. And that is the one that notes that we learn more about PFAS, because PFAS chemicals, the more we can learn that certain PFAS can cause health risk at very low levels. That is why anything we can do to reduce PFAS in water, soil, and air can have a meaningful impact on health. I want to point out that Lafayette Pointer is adjacent to Rock Creek Park, which is our national park. And we do have to be concerned about runoff concerns as it relates to our national park, Rock Creek Park, and the environmental concerns that come from the runoff, in addition to the other concerns. We're not scientists, but everyone has agreed that everything they have read has said, this is inconclusive. We are not sure. Yet what we are sure about is that this field will be used by our children, our most vulnerable residents here in the district. So to say that we are unsure and unconclusive about something, but move forward with the risk that our children are sort of the test of this, I think is also a concern that that should be considered here as well. I'm not going to go back and forth about the budget concerns because the numbers have changed. I do want to speak to Councilmember Trayon White's issue. And I want to note that a few things is that the crumb rubber issue is sort of different from the community's concerns about Lafayette. But I do want to note in 2017, the district banned crumb rubber because of fears about its toxicity at the time. DGS made the same argument about crumb rubber in field that they are now making about PFAS, stating in a 2017 fact sheet posted to their website that reports and studies on crumb rubber in field do not conclusively prove its harmful effects. So I just wanted to note that as well for the record. Again, I ask that you stand with the community here in our very real effort that we have already made for months to resolve this issue. Thank you.
There's no further
Mr.
discussion.
Chairman,
Why that provokes some. Councilmember Robert White and then Councilmember Pinto.
Thank you, Chairman. And when I chaired the committee on government operations, there was a lot of desire for grass fields and a lot of opposition to turf and artificial fields for reasons that most of them I agree with. One of the issues with grass fields, though, is that when there is very heavy rain, it turns to mud, and generally it has to dry pretty thoroughly before it can be played on, or that mud like gets run over and hardened, and the field can be permanently destroyed. There are also concerns about overuse of fields, which diminish its ability to be used. So I generally support this, but I'm wondering how we should how you recommend we deal with these concerns, Councilmember Louis George.
Councilmember?
What was the question? I'm sorry. I'm so sorry. What was it?
Grass fields,
Oh,
when
yes.
when they get a lot of rain,
Mhm.
get muddy and can't be used. If they're used before they are completely dry, the mud like bunches up. It destroys the grass, creates a lot of divots in the grass. If the grass is overused, it can be destroyed as well. So one of the primary arguments when I chair government operations was durability, usability of fields. So how do you balance the concerns about inability to use the field because of excess rain, because of needing it to dry, or because of overuse?
Yeah, I think there are trade-offs between artificial and natural grass field. While natural grass field needs time to rest in the winter, actually artificial turf fields are less usable during the summer and the beginning, which is the beginning and the end of the academic year, because they are become extremely hot. So there's always going to be a trade-off there between the two. What I will say is that the community is well aware of the trade-off of in this instance, and they have said we prefer the trade-off of natural grass versus the trade-offs presented by artificial turf.
Thank you, Jim. I was just asking my remaining seconds. There was a desire expressed in the breakfast meeting to have a hearing on this more broadly. So I hope that's something that we can do. Thank you, Chairman.
Thank you, Councilmember. Councilmember Pinto.
Thank you, Mr. Chairman. And thank you so much, Councilmember Louis George. As a fellow ward council member, I am very sympathetic to the fact that you've heard from so many in the community about this and are trying to move forward in a way that advances their safety and what they are asking for. I guess as I contemplated this earlier, I was thinking about from a perspective of deference to my ward colleague and what your community wants. I guess I'm curious from the perspective of our entire matrix of field space, if this were to move forward and the contract would have to be rebid to figure out who's going to implement the grass and then maintain the grass, would that have an impact on other playtime and kids and games that would have to happen at other fields, kind of in the surrounding areas and perhaps in other wards?
I'm unsure sort of as far as what would happen with the other fields and surrounding areas. The Lafayette Pointer Field is used by the school and by the Chevy Chase, Hawthorne, and Barnaby Woods communities. And so during the school year, I'm not sure what that direct impact will be. I just know that during the summer, it's just open for community. And right now, that's why right now they're working on soil erosion for the soil erosion project on the upper field, and why they were beginning the project now, because it's the summertime. And so they usually begin their projects that are sort of seasonal sensitive at that time.
Gotcha. Okay, thank you for that context. I guess I'm just thinking about other examples where we've
I
had
think the
grass.
field can be used if there's an issue with getting new grass.
It can be used in the meantime.
Yeah.
Mr. Chairman.
Somebody has to be recognized. Councilmember Henderson.
Thank you, Mr. Chairman.
Mr. Chair, I
Sorry, go ahead, Councilmember Pinto.
sorry, I thought we were just in the middle of a discussion still. So if the field can be used in the meantime, then do we have any way of knowing like the level of frequency of maintenance that would be required for grass versus turf and if that would impact the ability to use the field?
DGS already has a maintenance schedule for the many natural grass fields that we have across the city, which this isn't the only natural grass field we have across the city, particularly not even in Ward 4, where we have Fort Stevens Recreation Center, which is also a grass field, and multiple others. And so it would just be on the same maintenance schedule as the rest of our fields are. DGS mows and manages fields all over town on their own. And so whether they actually implement their maintenance plans, which I think other council members were alluding to, I think it's a different question. But right now they have a maintenance plan and schedule for natural grass fields in our throughout the city.
Thank you.
Councilmember Henderson.
Thank you, Mr. Chairman. Not trying to belabor, just trying to get to a resolution here. So I want to ask Councilmember Lewis George, is there do you believe that with more conversation between DGS, the executive, and the community, that there could be a resolution here without requiring us to vote on an emergency legislation on this particular matter?
Well, at this moment, I mean, the executive has dug in a way that has not been open to sort of any change of thought or community opinion here. Without going in too much into conversations, it's just the executive fundamentally disagrees doesn't like natural grass fields. I don't know a better way to put that. So it's sort of either we are going to force on the community a decision that one believes is best, or we're going to listen to the community, our taxpayers, what they would like to have in their community. I think that's just a difference of servant leadership styles, honestly. So thank you.
Councilmember Henderson.
Motion to close debate? Close debate.
Sure. Is there any objection to a motion to close debate? Hearing none, all right, then.
What about a motion to table for a month?
Okay.
For the purpose of
So,
trying to
there
all
was
work together and
hate to do
accommodate.
this. A motion, there was a motion to close debate. I asked if there was any objection. I heard no objection. So debate was closed. Anyone who has not spoken can speak. But Councilmember Pinto, you've already spoken, so you can't speak and therefore you can't make the motion.
Well, my secondary motion was my form of objection.
So is there anyone who has not spoken?
To Christina's motion? Because I was
No,
seconding.
no,
I
it was-
seconded.
Nobody objected to her motion.
Oh, yes. Okay, great. Close. Got it.
I'm asking if there's anyone who has not spoken. Not hearing anyone. Stop it. All right, we have the bill, we have the declaration before us.
Request the roll call vote, please, Chairman.
Madam Secretary, would you call the roll? The vote is, wait a minute, the vote is on the declaration. Madam Secretary. Correct.
Councilmember Trahan White,
Yes.
Councilmember Trahan White votes yes. Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
No,
Councilmember Bonds votes no. Councilmember Freeman,
Yes.
Councilmember Freeman votes yes. Councilmember Gray is absent. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
No.
Councilmember McDuffie votes no. Chairman Mendelson.
No.
Chairman Mendelson votes no. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Mr. Chairman, there are 9 yeses, 3 nos, and 1 absent.
The declaration is approved. We have the underlying bill, Bill 25-807, Councilmember Lewis George. Council members.
So moved.
It's been moved. Is there discussion on the bill? By voice vote? Heard somebody say yes, please. On the bill by voice vote, all those in favor say aye.
Aye.
Are there any opposed? Just a moment of conversation. You want to be recorded as no? No. If nobody wants to be recorded as no, then the ayes have it unanimously. The ayes have it unanimously. So the bill's approved. We have the temporary before us. That's fun. All right, Councilmember Lewis George,
I move the underlying emergency amendment.
you're not paying attention. The next measure on the agenda is Lafayette Elementary School Grassfield Temporary Amendment Act of 2024, Bill 25-808. Councilmember Lewis George,
So moved.
discussion? All those in favor?
Mr.
of the bill,
Chairman?
please. Councilmember Pinto? Did you want to
Can
be
I move-
recognized?
I do. Can I move to table the temporary for an additional month so we can try to work out with DGS what their concerns are?
That would be a motion to postpone for 1 month to the June 11th legislative meeting.
Yes,
You can move that if you want.
I'd like to move that.
All right, we have a motion to postpone to June 11th, consideration as a temporary. On the motion to postpone, is there discussion? All those in favor of the motion to postpone, say aye. Opposed?
No.
The ayes have it unanimously.
Mr. Chairman? Mr. Chairman,
Yes, Councilmember Parker.
I do believe I heard at least one objection.
It was a voice vote and it was
Okay.
approved.
I
The
mean,
motion to postpone was approved.
I do believe it passed, but just for accuracy's sake, I don't know if it was unanimous.
I didn't say it was unanimous.
You did say it was unanimous.
Oh, I did?
Yes.
Maybe you're not paying attention.
I didn't hear that. Probably good I didn't hear that. All right, let me clarify. The motion to postpone the temporary was approved by voice vote. Did anybody ask to be recorded, Bill? No? Councilmember Fruman, I know, but I have to say it. Councilmember Fruman will record it as no. We get to other business. And I've been having such a good time that I'm not ready for this. Under new business is a motion to override the mayoral veto of Bill 25-780. The bill is the Local Rent Supplement Program Eligibility Emergency Amendment Act of 2024, Bill 25-780. In her veto message, the mayor asserts that the self-certification process impugns, that's her word, the ability of the housing authority to do due diligence on applicants. I will note the housing authority testified on the permanent version of this bill last year. They did not raise that concern. The legislation allows for self-certification only, and I'm reading from the bill, when an applicant cannot easily obtain verification documents, quote unquote. As we've seen and heard from countless stakeholders, the process for obtaining verification documents, particularly for homeless individuals, can take months or even years. Allowing for self-certification in circumstances where these individuals do not have immediate access to required documentation ensures that they do not remain homeless due to bureaucratic processes. I want to note that this bill is about getting a voucher. It is not about going through the application process for a rental unit itself. The mayor also claims that the law creates a security threat to district residents by precluding the authority from considering prior arrests or convictions when determining eligibility. Again, this is about the application for a voucher, not the application for a rental unit. This provision in the bill is meant to ensure that criminal records are not a barrier to getting people housed. And the mayor in her veto message or at any other time has not cited any data, statistics, or even anecdotes to support the contention that this law impacts the safety of district residents. And I would note further that this concern also was not raised by the Housing Authority. Now, when the mayor when the council first approved this legislation, which was in July of 2022, the mayor actually signed the bill. When the council renewed the emergency 1 year later, the mayor wrote, and I quote, "I would like to continue working with the council," unquote, on the underlying concerns. However, she has not. So not only are the allegations in her veto letter unsubstantiated, but she has not worked with the council with this. In fact, when the Committee on Housing had a hearing on the permanent bill last summer, DHCD simply did not testify on the bill. They testified on another bill, but not this one. The genesis of this legislation is to make it easier to remove barriers for those who are homeless and those who are undocumented to be able to apply for vouchers. Apply for vouchers. Subsequent to that, assuming they get the voucher, they would have to apply for a rental unit, and there is a vetting process then. So the mayor raises concerns that have not been raised before. The mayor has not worked with the council, either the Committee on Housing or with my office, with regard to her concerns or how to improve the bill. The permanent bill is in the Committee on Housing and will be reported out, I think I can say, before the recess. And the Housing Authority has not raised these concerns that the mayor is raising in the name of the Housing Authority. For all those reasons, the veto is, in my view, not substantiated and it should be overturned. And that is my motion to override the veto. Further discussion? On the motion, all those in favor of the motion to override the mayoral veto, say aye. Aye. That was weak. All those opposed?
No.
The ayes have it. Does anybody want to be recorded as no?
Yes.
Councilmember Fruman will be recorded as voting no. The motion is
Mr.
approved.
Chairman,
Yes.
please record me as present.
Councilmember Parker will be recorded as present. That will conclude the business for this meeting. Just a moment. What?
So, yeah, council rules says temporary has to be moved at the same time. Secondly, on the other hand, no.
General Counsel has pointed out to me that the motion to postpone that temporary was somewhat at odds with a rule, but it could be construed as suspending the rule that requires the temporary has to move simultaneously with the emergency. My interpretation would be implicitly that rule 413 was suspended. I want to note before we adjourn that although the agenda states our next legislative meeting is June 11th, the Committee of the Whole will be meeting on May 29th to adopt its committee print for the budget and the Budget Support Act. And the council will have an additional meeting that same day to consider the Budget Support Act and first reading on the Local Budget Act. The supplemental will be its second reading, which I believe is June 12th. And second reading on the Budget Support Act will probably be shortly after June 12th.
Mr. Chairman, does
Yes,
this mean that there will not be a committee of the whole meeting on May 21st?
no, there will be a committee of the whole meeting on May 21st. I think. I misspoke that, a number of members will probably be at the ICSC, conference or coming back on the 21st. So there probably will not be a committee of the whole that day. If there's need for an additional committee of the whole before the 29th, I'll consider it, but otherwise our next committee of the whole will be on May 29th. Thank you for catching me on that. If there's nothing else, and I think there's nothing else, the time is 2:53 PM. This meeting's adjourned.